Sekejap. Merah tak keluar. 1, 3, 2. Okey.
Okay, Assalamualaikum everyone and Dr. Mahbubul Haq. We are from group 2 and this is our video presentations. The title for our video is Diplomatic Negotiations, whether complementary or contradictory with the judicial settlement in the case of international dispute. Okay, for our group members, my name is Ahmad Muhammad bin Abdul Halim. And other members is Adam Haikal bin Ahmad Husni, Wan Abdul Syukur bin Wan Muhammad Kasim, Sheikh Ahmad Kamil bin Sheikh Muhammad Hamdan, Muhammad Husairi bin Khalid, and the last one is Muhammad Saiful Azrael bin Nur Akmar. Okay, for the introductions, international dispute is disagreement over a fact, a legal principle, or a piece of policy where one party makes a claim or assertion and other respond with a denial, a counterclaim, or a refusal. Negotiation is one of the methods that is often used to resolve international dispute. Negotiation is the process of resolving differences through compromise rather than debate or argument. Another method in an international tribunal is international tribunal settlement of dispute through the judicial process in accordance with the rules set forth by the international law. Issues regarding international negotiation to unravel the problem that arise regarding whether diplomatic negotiations is either complementary or contradictory with the judicial settlement in the case of international dispute. Okay, next presenter.
So we're gonna look towards the negotiation as diplomatic method in settlement of dispute. Next slide. So the most basic method of resolving. Do you guys hear me? Hello?
Yes, we can hear you loud and clearly. Please continue your presentation.
Yes, go on.
Okay. Negotiation. The most basic method of resolving dispute is negotiation. And the parties to the conflict exchange information back and forth in an effort to resolve it. Treaties frequently refer to negotiation as the principal means of attempting to settle a dispute. For example, in Article 283 of the UN Convention on the Law of the Sea, provide that the parties to a dispute arising under UNCLOS should proceed expeditiously to an exchange of view regarding settlement by negotiation or other peaceful meaning. Conflicting parties can frequently come together to talk about the issue and come to a consensus. It's a commonplace to negotiate resolution to a conflict. For instance, if our adolescent asks for the car keys, we might debate the matter and come to an agreement on the terms of use and the time to return home. A negotiation example like this one. Negotiation technique and abilities can be learned. We might read books or enroll in classes to develop our negotiation skill. And in some circumstances, it may be preferable for us to work with a lawyer, advocate, or counselor who has the knowledge necessary to support us during negotiation or who can act as our champion. So moving to the next presenter.
Next one will be the legal method as a decisive adjudication. The approach that is based on the law is called the legal method. Arbitration and judicial settlement are two prominent examples. The first one is the International Court of Justice, or ICJ, the most important judicial body on the international stage. ICJ composed of 15 judges with two purposes and responsibility of resolving legal disputes between nations that have been referred to them and rendering advisory opinions on legal matters referred to by authorized United Nations institutions and specialized bodies. The next one will be arbitration. Arbitration is a legal method for the resolution of conflicts that requires the mutual consent of all parties involved in the dispute, or more specifically, a meeting of two or more parties to consider the problem. It can be carried out with just one arbitrator, or it can be carried out with three arbitrators who come to an anonymous judgment that is legally binding. In most cases, the parties to the dispute first choose one arbitrator for themselves, and then the initial arbitrator chooses other arbitrators to help decide the issues. I will pass to the next presenter. Adam, please open your mic.
Hello, hello.
All right.
Okay, thank you. So the usual order of dispute settlement. Okay, next slide. In modern treaties, it is common to see a combination of diplomatic and legal means to achieve the objective. So diplomatic means refer to the use of negotiation, while the arbitration use the law as a force. So essentially, one might see that international dispute are much more flexible and dynamic with respect to diplomatic negotiation and arbitration. So one case that we could be an example is the Convention Against Terrorist Financing, which states that disputes must be resolved through negotiation, and if that is not possible, through arbitration, and if that is also impossible, the dispute may be referred to the ICJ. Okay, next slide, please. Okay. However, this convention allows us to reach a prevalent answer that the combination of diplomatic and legal means in modern treaties allows for a more comprehensive and effective approach to addressing the issue at hand. Just like what has been stated in these slides for private and domestic effort. So I will pass to the next presenter.
Okay, for the other alternative dispute resolution, first is mediation. People involved in a disagreement may request the assistance of a mediator, a neutral third party, in their negotiation. When negotiation has failed, the mediator can frequently assist in reducing conflict and fostering communication between the parties. The fact that the mediator assists the parties in reaching a satisfactory resolution as opposed to one that is intended to establish right and wrong is a typical justification for selection mediation. The parties typically split the expense of mediation. Lawyers are typically not required to be present during the mediation process. For the second is conciliation. Conciliation is a third-party process which is generally involved a fair examination of dispute by conciliator of or conciliation commission. Parties are required to carefully consider the proposal from the conciliation commission, but they are not binding to the proposal. For example, 1980, the Iceland and Norway dispute over a continental shelf delimitation between Iceland and Jane Mayen Island. For the third is fact-finding and inquiry. Inquiry and fact-finding are processes that are especially intended to produce an unbiased determination of disputes, facts, and also involve their third parties. Parties may request to establish a commission of inquiry consisting of a competent observer to evaluate the dispute fact. For the last is the inquiry took place in early 1905 in the Gaban incident that involved Russia and United Kingdom. For the last point is good officers. Good officers are typically thought of as being less proactive than mediation. Good officer does not participate in the negotiation and their offer and use is not obligatory for the disputing parties. Okay, for the next presenter, please.
Okay, thank you. Next slide. So, as a conclusion, there are various roles in dispute settlement that needs including as diplomatic negotiation and many more. These roles is function as a tools to find a common ground for conflicting parties. Diplomatic effort can be used to negotiate a settlement which is then formalized through a judicial process. However, but diplomatic negotiation and judicial settlement are used. Diplomatic effort can be used to negotiate settlement. However, the contradictory if the diplomatic negotiation and the judicial ruling produce conflicting result. In such cases, finding a way to reconcile the two may be necessary in order to reach a resolution that is acceptable to all parties involved. That's all from us. Thank you.
Okay, thank you everyone.